Swayam Prabha. Digital India. Educated India.
A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello everyone, this is Professor Shivani Goswami and I'm teaching in IP University. I have been taking few lectures on Hindu law. Today is my 9th lecture. I have already taken 8 lectures, and before I start with my 9th lecture, I will just have a recapitulation of what we did in our 8th lecture. Now, in my 8th lecture, I talked about partition, and I also talked about a few provisions of the Hindu Succession Act, that is 1956, and also an amended Hindu Succession Act of 2005. When we talk about partition, we know that the only way to bring joint family system into an end is to go through partition. So, by partition, joint family, it comes to an end. This is the only mode through which a joint family system can come to an end. Now, for a partition to take place, we know that the person should form an unequivocal intention, number one, and this intention needs to be communicated. So, until and unless this is communicated to the interested parties, it is communicated to the co-partners of the family, that partition is no partition at all. So, you need to have an unequivocal intention, though you need not assign any reason, you need not assign any motive. The only thing is, because in the Mitakshara, since you are born with the property, whether it is a son, grandson or great-grandson, the thing is you are there with the property at any point of time, you can ask for partition and take away your share. So, you need not assign the why do you want that thing, what are the reasons, so you don't have to tell it to anyone. Then another thing is, we talked about certain people who could demand partition and who also get a share when the property is divided. So, obviously, these are the co-partners in the family, and we know that co-partnery is something which is limited in number and it is not same as the joint family system. A joint family, we had discussed, it's a broader institution, it's a wide institution, it's a genus of which co-partnery is a species. It consists of members of the joint family, but not all members of joint family. So, when we consider about the Mitakshara, it is confined to certain number of people in the family, and these are the co-partners whose most important right, whose most pivotal right is the right to demand partition of a joint family property. So, all co-partners, they have got a right to demand partition and also to take a share when the property is divided. Earlier, it was only son, son, son or son, son, son who could demand partition and get a share. But now, with the amendment in 2005 Act, Hindu Succession Amendment Act 2005, the daughters have also been included, and since they are co-partners in the Hindu joint family, they can also demand partition of the joint family property. Apart from this, there are certain females in the family who do not have any right to demand partition, but whenever the property is divided, the thing is they also get a share in the property. And these females, limited females are, it could be your father's wife, it could be your widowed mother, it could be your grandmother. So, these 3 females, that is the father's wife, your widowed mother and your grandmother, they are the ones who cannot demand partition, but they definitely get a share when the property is divided. Then, apart from this, we talked about total partition, we talked about partial partition. Partial could be with respect to the persons, with respect to the people, and when you talk about partial as to the property, it could be as to the, for example, in some of the states, the fragmentations of the holdings are not allowed. Then it's relating to the property. Some properties are disputed property. So at the time when you are dividing, you are unable to take that thing into consideration, and that's a case of partial partition with respect to the property. When we talk about partial with respect to the person, it might happen when you need to divide from the family. All the members are not interested. That means all the co-partners are not interested to divide there and then only. Some of them might be interested, some of them might not be interested. I took an example that A is the father and B, C, D are his sons. If B wants to divide, then his severance of status would take place there and then only when he has demanded partition, but the rest of the family, that is A, C and D, would continue to remain joined. So that's a case of a partial partition. Total partition is when all the members, they want to divide and they take away their share, partition takes place. For example, if there are 4 in number, A, B, C, D, then each one of them would be taking 1/4 of share and would be dividing, and they will be getting partition amongst themselves. So that's a case of total partition. Then we talked about certain rules relating to the division of the property, and I had drawn that also, and we had discussed it in detail, how the property is being divided, how people at the time of partition they are taking their share. Then we also talked about reunion, we also talked about reopening of partition, and that was what the partition was. And apart from this, we also discussed about succession of a Hindu male. Now, I had started with that thing, and we were talking about Hindu Succession Act 1956. We were talking about Hindu Succession Amendment Act 2005. I talked about certain provisions relating to both the acts. Both the acts, in the sense, 2005 is an amendment of Succession Act 1956. Now, I stated that it came into force on 17 June 1956. And the Hindu Succession Act 1956, it dealt with the property of a Hindu male, it dealt with the property of a Hindu female, it talked about certain disqualifications. Basically, when you are dealing with Succession Act, majorly it's a self-acquired property of a person, and this person has died intestate. That means the death of the person. It's a legal declaration of the intention of the testator with regard to his property, which he desires to be carried into effect after his death. So that means will always take into place. It always come into operation only after the death of the person. If the person is alive, then even though he has made that will not be operative. It will not come into operation. It comes into operation only after the death of the person. In this case, there are certain terminologies that we had discussed. We talked about as to who is an intestate, who is an heir, who are half-blood children, who are uterine blood children, who are full-blood children, and who are ascendants, who are descendants, collaterals. Collaterals are the cousins in parallel lines. So these are the certain terminologies that we had discussed. And as far as the Hindu Succession Act is concerned, there were certain provisions which were, there was a disparity. For example, section 23 was there in it, and it talked about rules relating to the dwelling house, and which stated obviously that till the time a male is there, the females, even though they have a right in that dwelling house, they cannot demand partition. It is the male, if he chooses to divide the property, then the female would be getting the share. They have the right of share in the property in that dwelling house right from the beginning. But till the time the male is living, for example, their brother is living, then even though the sisters have full right in that property, but they cannot take it till the time brother chooses to divide it or to go away from that house. Because he is living in that house, he is dwelling in that house, so you are not allowed even to have a share in that property, but you are not allowed to ask for your share in the property. It is only at the discretion of your brother, or when he decides it, then only you can get the share in the property. And in this only, again, right to residence were given to limited number of women. For example, if you are an unmarried woman, or if you are a widow, or if you have been deserted by your husband. That means if you have deserted your husband yourself, then you do not have a right to stay in that house also. It is for you to stay in that house, it is necessary that your husband should desert you. If you have gone for desertion and you have yourself deserted your husband, you lose this right of residence in that house. So this is what this section 23 talked about. And it was that there was a disparity. We boast of, we brag of equality, we talk about egalitarianism, we talk about parity. And Article 14 of the Constitution, which is a fundamental right and is available to the citizens of India, it's not into, if you see it, it was not coming into true light, because still there was a disparity as far as this section was concerned. But with the Amendment Act of 2005, this disparity has now gone, and now this has been omitted. Then section 24 also had been omitted. It used to talk about the widow of the brother. It used to talk about the widow of the predeceased son. It used to talk about the widow of a predeceased son of a predeceased son. And it stated that if during the time the succession opened and they have gone for another marriage, they lose their right in that property. So they do not have any right in that property. The 1956 Act talked about class 1 heirs in the case of a Hindu male, that is the propositors. Now, the rules of devolution were that first of all, the property used to go to class 1 heirs. They were all the nearest relative of a person. The father is the only nearest relative who couldn't find his place in class 1 heir. He belongs to category 1 of class 2 heirs. Among the class 1 heirs in the 1956 Act, we have 12 heirs which were the closest relative of the person. But with the Amendment Act in 2005, the number has increased. 4 more people have been added into it, and it has come to 16 now. So that means class 1 heir, it consists of 16 heirs who have got a right to take the property first when a propositus dies. He has died without making a will. It is his property, and after he dies, the property they have the first right to claim that property. And if none of them are there, even one is not there in class 1 heir, the property devolved on class 2 heirs. I have stated that there were 9 categories in this class 2 heirs, and the earlier category, it excludes the later category. If none of them are there also in class 2 heirs, then the property used to go to the agnates. Agnates were, if between the claimant and the propositors, all are male. So that means the sex of the person who has to claim the property, that is immaterial. If in between the line between the propositors and the claimant all are males, then that means this claimant is an agnate of the propositors. But if in between a female intervened, that means that person is a cognate of the propositors. The right first is given to the agnate, and if no agnate is there, it goes to the cognates. And if none of them are there, the property would be taken by the government. That means you do not have any relative, and it is called as escheat. Now, this was regarding the property of a Hindu male. The Act also talks about the property of a Hindu female. And in the case of this female is called as proposita, and in this the source from where the woman is taking property, it is very, very important. It is very, very noteworthy. It is very, very significant. So that means she could take the property from the other sources. She could take it from her parents. She could get it from her in-laws. And so there are different set of heirs. If we talk about the other sources, there are certain entries, A, B, C, D, E. And if she is taking from the other sources, that is other than the parents and in-laws, then first of all, the property would devolve on her nearest heirs, and these are son, daughter, husband, son and daughter of a predeceased son, son and daughter of a predeceased daughter. If none of them are there, it will go to entry B. In entry B, we have the heirs of the husband. So that means they are all the stepchildren of this woman who take the property, if none of them in entry A are there. If they are also not there, it will go to entry C. Entry C talks about the father and mother of the proposita. that is this female. And if they are also not there, it will go to the heirs of the father, and lastly it will go to the heirs of the mother. So this is a rule, and it cannot be that you can bring entry E first. You need to bring entry, it has to go chronologically A, B, C, D, E, in this way only. If the woman takes the property, next is, if the woman takes the property from her parents, if she has taken it from her parents, the heirs are, category 1, it talks about son, daughter, son and daughter of a predeceased son, son and daughter of a predeceased daughter. So that means husband here is not an heir. So if she had taken that property from her parents, husband will not get any share in that property. If none of them are there in this category 1, it goes to category 2, and in category 2, it is the heirs of the father. So that means we could take an example. It has also been provided in Paras Diwan. It states that supposingly the property has been taken by a female through her mother. And now if she dies, the father is also there and the heirs of the father are also there. The rule says, category 2 says, it has to go to the heirs of the father. Now the question is, where is the father? Will it be like that the father is also there and the heirs are also there? So you are ignoring father and then you are giving the share to the heirs of the father. So that there seems to be a somewhat loophole in this kind of a provision. The third is when she is taking from her in-laws. The rule is clear that in in-laws, if she has to take it from her father-in-law, she needs to be a widow. If she is a married woman, she can take it from her husband. So a married woman, if her husband is alive, she cannot in any case take it from her father-in-law. That is not there. She can only take if she is a widow. Now if she takes it, the heirs, the category 1 people again are the same. It is son, daughter, then son and daughter of a predeceased son, son and daughter of a predeceased daughter, and if none of them are there, it goes to the heirs of the husband. Now, when I stated that if the woman is widow, she is taking from the father-in-law, so it might happen that she has gone for another marriage also, and she has a children from that marriage also. Now, in this case, if she has children, the question is, which heirs are we talking about? Is it the heirs if she has taken it from her previous father-in-law? Is it the heir of her previous father-in-law, heirs of her previous husband, or the present heir of her husband? Obviously, it would be only in the family from where she has taken. If she has taken from her earlier father-in-law, it would be the heirs of that husband, to whom that person was a son. And if it is in this family, obviously it is the heirs of this family. So that what about the succession of the property of a Hindu female is talking about. If none of them are there, then again it is the government that takes the property, and this is called as escheat. Now one thing to be remembered here is that the Succession Act of 1956, section 14 has specifically stated that whatever property the woman is in possession of, at the time when this Hindu Succession Act 1956 had come into operation, if she was in possession of certain properties, she is an absolute owner of that property. So that means now she is not a limited owner. Whatever property to which she was in possession of during the time when the Hindu Succession Act 1956 came into picture, came into operation, that is, she becomes the absolute owner of that property. She is not a limited owner of the property. So if she is an absolute owner, that means she could dispose of the property during her lifetime the way she likes. Then there are certain other provisions also which are mentioned under the Act. For example, it states that whenever the property has to be divided, it is always the full blood children who are preferred to the half blood children. We have in our previous lecture talked about full blood and half blood. Full blood are your real brother and sisters. It could be your real brothers. When the children, they are from the same mother and father. So that means they are full blood children. So these children are always preferred to half blood. In half blood, the father is same but the mothers are different. And in uterine blood, the mother is same and the fathers are different. So we have already discussed that thing. Second is the rights of the child in the womb. I've already stated, and again I'm saying that if the woman is pregnant, a pregnant woman, if the child is in the womb of a mother, the child is in existence. So if it's a case of a posthumous child, in case of this, he is very well in existence, and he also gets a share in the property when it takes place, when succession opens. So he has also got a right. There is presumption in case of simultaneous death. It states that when it might happen in certain cases that two people die simultaneously. Now the question is, who survived the other? The presumption is the younger always survived the elder. So that means if two persons are there, and this younger thing has to be assumed by relationship and not by age. And then so it is always, the presumption is that a younger person always survives the person who is an elder one. Then murderers are considered to be disqualified if it is in furtherance of succession. If it is not in furtherance of succession, then they can very much take the property of a person. I'll take an example here, and it's again there in Paris 1 only. This example is, for example, are having a fight. Say A is the person and B, C, D, E are his children. Now there's a fight that is taking place between the brothers. It could be on, say, any reason. It could be a faction fight, it could be related to some girl or something of any kind, and the children are, the sons are fighting, they're fighting like anything. And supposingly the father enters the room and accidentally he is being hit by one of the sons, and unfortunately the death of the father takes place. Now this is not in furtherance of succession. There was nothing relating to succession. So even though this person, it's because of his blow that the father had died, he will still get a property, he'll get a share in the property. But if it is a case which is related to, which is in furtherance of succession, and the murder takes place, then the child is debarred from taking the property. Let's take an example here again. It could be, for example, P is the person and he has two sons, A and B, and the A, he kills P in furtherance because he wants to get the property of P, and he kills P, or he abets this other person, B, to kill B. Even an abettor is liable. So now here the murder has taken place in furtherance of succession. It is in relation to the property. So both these persons, we have studied under our Indian Penal Code so many times that the abettor is equally liable. If you are instigating an offense, you are provoking someone, that means you are also equally liable. So you cannot be exonerated from your liability. You cannot be exempted. So you will also be liable for what you are doing. If I am the main person, I am abetting you, and due to my abetment, you kill another person, I will be liable. Definitely I will be liable, but you also, who has killed the person who has been abetted by me, you will also be liable for that offense. So that means if a person is himself killing or abetting another person to kill this person whose property it was, and it is relating to succession, then these persons are liable. These persons are disqualified from taking the property. So that means it's a bar, and you are not allowed to kill a person in furtherance of succession. If the murder had taken place due to some other reason which is not connected with the succession, then obviously you get the property, you get a share in the property. But if it is relating to succession, the principal person is liable and even an abettor is liable. So that both these persons are liable because they are killing that person in furtherance of succession. So that is not allowed. It is considered to be a disqualification. Then when we talk about the converts, people might convert, anybody can convert to another religion. That person has got his choice whether he wants to remain Hindu, whether he wants to become a Muslim or a Christian, as the case may be. The question is, if a person converts to another religion, I mean to say the child of this person whose property it was, the child of a propositus, if he is converting this interstate who is converting to another religion, whether he will get a share in the property or he will not get a share in the property. The law says if he is an immediate convert, then obviously he will get a share in the property. I'll just explain it with the help of a diagram here. For example, let's see here. Now this is A. If you see it, it says that this one is B, C and D. It says that now here, if supposingly the C, he converts to another religion. He becomes, say, a Christian or a Muslim, as the case may be. And now if A dies, now he is an immediate convert of the person. He being an immediate convert, he will definitely get a share in the property. So if the property is being divided, since there are three members here, it would be 1/3, 1/3 and 1/3. So that means immediate convert, there is no disqualification for that person and share in the property. Now there could be another example also. Let's see here. A, B, C and D. D has two children, say it's D1 and D2. Now here D has converted to another religion, and this person has earlier converted to another religion, and say he has two children. After his conversion, these two children were born. They are D1 and D2. Now, and if he dies, these two children are born after conversion. Now, if A dies, here the children of this D who had converted to another religion and they were born after conversion, they will not get any share in the property. If now the property is being divided, it will be divided into two parts here. It will be B will be taking half share and D will be taking half share. So it goes like this. The rule regarding to this conversion is that if it's an immediate convert of a person, then that is not a disqualification. But as far as his heirs are concerned, the question is whether they were born before conversion or after conversion. If they were born before conversion, obviously they will get a share. If they are born after conversion, they will not get a share in the property. The immediate convert gets it, but the scenario is different when we talk about the heirs of this kind of person. Before conversion, they will get, if they are converted before this thing conversion, and if they the property is divided and they have converted, these children were born after conversion, they will not get any share in the property. The last disqualification here, which I would be talking about, is about any disease, deformity, which is there. If a person is suffering from any kind of a disease or a deformity, the rule is that this is no more a disqualification. So even if you are suffering from serious diseases, could be HIV, it could be any venereal disease, sexually transmitted diseases, or any kind of a disease, or even if you are a handicapped or you have a deformed body, then that is not a disqualification. And even if you are suffering from this kind of ailment, the thing is, or this kind of handicap, you are a handicapped, these are not considered to be any disqualification. You are also entitled to equal property as the other persons are getting. So disqualification, that means disease, deformity, etc., they are not considered to be any disqualification anymore, and they are the ones who will also get an equal share in the property as the other persons are getting. Now this was regarding succession. I would be talking on my next topic, that is domestic violence. And as far as domestic violence is concerned, we always keep on hearing, we always say that women and inflicting violence on women, they are in each other's pocket. That means they are the two sides of the same coin and they are inseparable. You cannot alienate them. They are right from day one. It is stated also, women has been suffering from her cradle to the grave. So many things have been laid down regarding this thing. And during her lifetime, women is being tormented. She is being harassed and she is being made to suffer so many, there are so many violences being inflicted on her. It could be in the form of rape, it could be wife battering, it could be witch hunting, it could be female feticide, it could be female infanticide, so on and so forth. Now, of all these kinds of violence which is committed against women, what I feel is domestic violence is the most grim most gravest form of violence that is committed on her. I have my reasons behind this. Why I am saying so is because this is inflicted to her by her own very people, by her own people. I mean, it could be the husband, it could be any of your relatives in the house. So that is, it says domestic violence. That is violence which is taking place domestically within the four walls of the house. So, and the most reprehensible and appalling part is that it is committed by your own people. The people to whom you have confided with, the people with you whom you have opened your heart to. So this is committed by those people. You might have shared, I mean, you have confided so many things in your these people, but when they are the ones who are tormenting you, they are the ones who are pestering you, they are the ones who are torturing you, they are making you to suffer, they are making you to suffer ignoble hardships. So there is nothing worse kind of a violence other than this, which I would say is domestic violence. If you see it, when we talk about the causal factors of this domestic violence, I feel that we are living in although now society has changed, you might or you might not agree with me, but patriarchal society or a male dominating society is one of the most important reasons for inflicting domestic violence on a woman. We are always made, this is imbibed in our minds, this is ingrained in our minds, that the word he plays a very important role in our lives. And we need to obey this he word. And this he word, whatever he says, and you cannot go without this he word. So that means this person, he is very important, and is stated that after marriage, it is the husband who plays a very important role in a life of a woman. So we have this patriarchal society, it is always being ingrained even in the male child that you are male. You need to rule later on. You need to be dominating. You can't be submissive. So these are certain stereotypes which are ubiquitous and which were earlier also very much prevalent in our system. Second could be stress, anxiety or strain. We have so much of stressful life. It could be professional, it could be anything. So when you have this stressed life, maybe you have a stress in your workforce, in your office, and when you're coming home, this is there in your mind, and as a result of which, because this pressure is there, so whatever is being stated in the house, you become angry, you become aggressive, and it might lead to violence within the home. So it might result into your thumping or spanking your wives. So that's a case of domestic violence again. It could be, I'm just telling some of the causal factors. It could be women these days, they have become monetarily independent. They are no more fiscally dependent on their husband, and it might bring a sense of inferiority complex in the husband, and she might be an achiever. She might be doing very well in her life, and the husband is not that good. So this inferiority complex could also lead to the beating of the wife. It could also lead to her battering. Then it could be, the converse of this is also true. I mean, when the woman is monetarily dependent on her husband, the husband knows that she doesn't have any place to go. And this might result again in her beating, in her spanking, in her thumping, because he knows that where will she go? She is dependent on me. And the women, because she doesn't have any place to go, she keep on suffering all these torments. She is there to suffer everything, and she is there to bear all those ignoble hardships. Then dowry is one of the important factors. Dowry plays a pivotal role. Now, if you are bringing less dowry, we see so many, there are catena of cases. If you are bringing less dowry and you're not meeting the expectations of your in-laws, then again there is violence. Again there is battering. It could be there have been a research also so many times that when you have, during your childhood, you have witnessed your mother being beaten by your father, you also might later on turn out to be a very aggressive person, because during your childhood memories are still there. You are an eyewitness to the fact that your mother was being beaten by your father, and the same thing you will repeat. It could be another way also. You might become a very shy person, you might become very subdued person, you might go into something which is not called for, because these memories are really painful. So it might result into that also. So these are certain, some of the causal factors that I have stated. The woman doesn't leave her husband. She's there in the husband thinking that one day, one fine day, her husband will improve and everything will come to an end. Or she might even feel that this happens to everyone. She might even feel she is monetarily, she is fiscally dependent on you, and she might feel, where will I go? I do not have anything to earn. How will I survive? What will happen to my children? So many questions, it keep on cropping up, it keep on coming in her mind, and as a result of which she doesn't. And then of course it could be her love for her husband. She might love him even though she is being beaten by her husband, but she still have this thing that I love my husband, so I can't leave him. So these things are there, that even though the woman is being tortured, she is being tormented, she is being spanked, she is being thumped in her family, she is not ready to leave her husband. She is not ready to leave this home. Then, in order to protect this women, there was one Domestic Violence Act, Protection of Women from Domestic Violence Act. It came in order to curb these kinds of violence. It came on 26th October, then 2006. And after this, when it came, there are so many provisions which talks about as far as this act is concerned. Now, this act has been labelled as totally as women comrade, women chum legislation. It is totally one-sided. It is this much one-sided that the men, they are feeling that because it was passed on 26th October, it came to force on 26th October. So they have felt that every year they will go to Jantar Mantar and they will observe Barsi of this act. Because this is totally one-sided, where everything of men has been taken away. They have been robbed of, they have been taken away of all their rights. And if you see the provisions of this act, right from the beginning, when you talk about section 3, it talks about domestic abuse, and there are so many abuses that are mentioned. There are 5 abuses that are mentioned under the act. It could be physical, it could be verbal, it could be emotional, it could be economic, it could be sexual. So many abuses, and they are all in favor of women. If there is a physical spat, there are beatings, there are injuries on the body. Of course, it's a case of physical abuse. Verbal is again name calling, shouting. So all these, it could come under verbal. Economic, when you're not allowing her to use her assets, when you're not giving her money, you are troubling her economically, fiscally. That is economic abuse. Sexually is when you are showing her pornography. You are showing her some other things which are not called for. So these are certain abuses that are mentioned under the act. Section 4, it says that if any person has a reason to believe that the domestic violence is going to be committed, then he can make a complaint to the protection officer. And if he has done so, he is protected if he has done that thing in good faith. So that means you are exempted from liability if you have made a complaint in good faith. Now, the act is very wide in the sense that it is also calling the outsiders to come and report. So it's not only the women who would do it, even an outsider can come and he can make a complaint, and if he has made that complaint in good faith, he is exempted, he is exonerated, he is let free from any of the liabilities that are there. So he will not be liable if he has done that in good faith. Then it talks about there are certain protection officers. They have a lot of role to play under the act. They are the ones who are protecting women. They have so many duties that are mentioned under the act. It could be making of domestic incident report. It could be helping the women to even file a case under section 498A of IPC. It could be taking her to the medical and getting her relief done. And because, when domestic violence takes place, there might be a lot of injuries on her body, and he's the one who could take her to the medical and take her to the doctor to get herself treated. It could be that she could be chucked out of her house, and these are the ones ones who would take her to the shelter home that are being provided. Now, these women during that time, all of us can understand, they are not in that position. They are devastated, they are totally pissed off, and they are totally lonely and isolated, depressed. Lot of, it's not that when you are taking a person, when you are saying something that is not called for, the person remains normal. You have a lot of, apart from physical injuries or physical spats and all those stuff, mental injury is one thing that is so much. The women has so much ill effect of this domestic violence. It could be physical, it could be mental. There could be a lot of bruises. There could be a lot of mental agony, mental pain, insomnia. She won't be able to sleep. She has this fear every time that she's going to be kicked or thumped by her husband. Nausea, vomitings, sometimes suicidal thoughts, depression, so on and so forth. So many things. Even the children who are witnessing this particular thing, they are also not free from these agonies and pain. If you see in your home, you can very well envision an envisage. If you see in your home that your mother is being kicked and thumbed up every day and night by a person who is your father, these are long-lasting memories and they do not go away easily. The children are totally broken up, they are totally, and this might carry on forward in their life. Maybe throughout their life, because they have witnessed such brutal incidents, they have witnessed such obnoxious incidents, such pathetic incidents in their life. And who is the victim? It's not only the mother, even the children. Their whole life is there. And every day they are witnessing such kind of obnoxious incidents. So that really has a great impact on these tender minds, which might last forever. So when the woman is being chucked out, she is the one who is totally devastated. She doesn't know where to go, and it is this act is there to bring remedy to her, to bring legal succor to her, and these protection officers are there to help her out, to take her, and because she is not in that situation where she could go to the medical officer and get herself treated, or she could go and take a shelter home for herself. So these provisions are provided under this Domestic Violence Act, and these are the persons. It's not only these protection officers, even service providers are there. These service providers are basically the private organizations and registered under the Companies Act. So these NGOs and all those things are also there. They can also take her to the shelter home. They can also provide her with the medical facility which is available under this particular act. Apart from this, there's a certain duties of the central and the state government, and it says that a lot of propaganda needs to be done. People are, there are so many laws otherwise also. We are not aware, because there is no propaganda. Until and unless awareness is there, until and unless sensitization is there, people are not, they are totally ignorant. It's not only illiterate people, we are not talking about illiterate people here, even the literate ones. Until and unless they are aware as to what are the things that are available to them, it's of no use. That is still, it's only on black and white. It is just in writing. So you need to be aware so that you are able to take the legal succor, you are able to take the redressal that is being available to you. Then, for this an application has to be made, and it has to be seen by the magistrate that within the period of 3 days, this case is being heard, and he also has this power to send it to a counsellor. If he feels that counselling is required, he might take it that, the women and the husband, both, even a single person can go, but if the magistrate feels that her husband also should go in this, so he can make both the parties to go and meet a counsellor. Now, history is evidence, and counselling has played so much tremendous role in the life of people. Sometimes people are not that much, they take things very nonchalantly. They have a very casual approach, and you are the ones who are not thinking about your future. So sometimes counselling can play wonders. So the main purpose of this is to send it to the counsellor so that he's there to counsel you, and he might change your mind, he might make you a better person. Then this is required, and then the magistrate should see that the next hearing, even if he sends you to the counsellor, he needs to see that the next hearing should be within a period of 2 months. So all this thing is there so that early disposal of the cases are there, because we know that things keep on pending in the court, there is backlog, there is so piling up of cases, and so for the easy and better disposals, for the speedy disposal, these provisions are made. Then camera proceedings are also there. Family matters are very sensitive matters. The person might not want to disclose it. He might want that it should be there in the camera only, and he doesn't want to disclose outside. So the provision of these camera proceedings are also there, which is going to help out. One very important concept under it is the concept of shared household. Now, we usually see in domestic violence cases that after this kind of violence takes place, the woman is being chucked out, she is being kicked out from the house. And now the question is, where should she go? She doesn't have any place to go. It might happen that she doesn't have any place to go. We say that shelter homes are there and provision of shelter homes is also there under the Domestic Violence Act. But if you see the reality, these shelter homes are very skimpy, they are very less, few in number. Then whatever rules and obligations, it's more like a prison. So you won't even feel like staying in those shelter homes. The security is not good. You won't like to go and visit that place. So if she is being chucked out, where will she go? Now, it's a very welcoming provision under the Act that now the husband doesn't have any right. She has also a right to shared household. Then even though the case is going on between husband and wife, the wife has got this remedy and she can continue to stay in the place where she is residing. The husband is not allowed to chuck her out. And if she doesn't want that, she should stay in that particular house, because when the case is going on, it really becomes difficult. You are facing each other. Things have gone beyond repair now. You have gone the court. So if this is the situation, then the husband can, he can take a house on rent, and the woman can be shifted there. And the rent, everything would be paid. It would be borne by the husband. He's going to bear that expenses. Then the Act talks about so many orders. It talks about protection orders. It talks about custody orders. It talks about compensation orders. It talks about residence orders. Residence orders, it's section 19 of this Act particularly says that if the woman has this thing that the husband is going to again torture her, or he's going to have this, again he's going to beat her, something domestic abuse is going to take place, then the court might protect her in the sense that the husband or his family members would be prevented to visit the place where the wife is staying. So they're not allowed to do it. So these protection orders are there. If she has an assets, they could be prohibited from using those assets. So wherever she's working, they might be prohibited from calling her up. So the purpose is that they should not remain in touch, because there is this thing that domestic violence might take place. So this is also there. Then compensation is there. You have suffered so many injuries. It could be mental injury, mental harm. It could be your loss of expenses. It could be the treatment on medical expenses. So all these has to be borne by the husband. These provisions are there. Then if anything, if the protection, there is a breach of protection order, then again a punishment is also prescribed under this thing. A compensation is also prescribed, and this has to be borne by the husband. So that means penalty is also there as far as this Act is concerned. Now, the offence is again non-bailable. Now you can very well envision it's a non-bailable offence. So that means everything, when we have, I have talked about some provisions of this Act, and if you see it, if you ponder over it, these are all in favor of women. And that is the reason why men have been pissed off by this Act. This is totally a women comrade legislation. It's totally a women-friendly, women-centric legislations where men is not having any role to play. So if you see the definition of abuse, that domestic abuse, so many abuses, physical, verbal, emotional, economic, sexual, so many abuses. What if the similar thing is being committed by, now their contention is, the contention of the men, what if the similar thing is being played by, it's done by a women? Women are also these days guilty party. They are not all the time victim. Then you're saying that you have made it a non-bailable thing. After having that perfect example which we used to have of section 498A IPC, on one complaint, the whole family of the husband or the husband, they are behind the bars. and the parents who are aged, old, on just one complaint of a woman, you had made it non-bailable. Then upon sole testimony, one of the provisions says it would be believed that domestic violence had taken place. You are giving place to live-in relationship. Live-in relationship are covered under it. What about marriage? That is the thing that we boast of. We cherish it, we revere it, we respect it in our Hindu society. Marriage plays an important part. So that means now these things are all going. You are giving place to live-in relationship where people are living without getting married to each other as husband and wife. So these are certain things now which are there, and apart from this, they say that how can an outsider come and say that domestic violence, how does he know what is happening in the four walls of the house? It might be that he is at daggers drawn with you and he just makes a complaint and then say it was in good faith. So he is exempted, he is exonerated from the liability. These are not called for. It's totally against men. Laws should be such that they should be gender neutral. In today's society, women are not that victim. There are so many women who are spiteful, who wants to take revenge. And it's the men, who are suffering also. In mental cases, so many cases, and total cases I had seen that women are in a dominating position. Men are, they don't have any remedy. Physical abuse, of course, physically they are more stronger. But when you talk about this mental abuse, women, in those cases, the women are more stronger. I had also stated earlier that I did my PhD on cruelty, and I couldn't find a single case where men were in a dominating position as far as mental cruelty cases were concerned. All cases women were there, and they were harassing and tormenting and torturing their husbands like anything. So these needs to be pondered over, and laws should be gender neutral. It should not be gender biased, because if we make it gender biased, then obviously it's one party is obviously has a strong footing, and they are the ones who are there who would be taking spite, who will be taking revenge, and who will obviously make misuse of those women comrade legislations. So these things should be avoided. We are seeing that in so many cases, women are misusing the laws, and this has been endorsed by judiciary, by police, by criminal administrative machinery, where they say that these days women are also misusing the laws that were brought into existence for their betterment, for their amelioration, to perk up their position. So that needs to be taken off. Last thing that I would be dealing under it would be open marriages. It's a very new concept, so that means we don't have that much on this thing, not in India that much. It's basically in this, you have nowadays open marriages. We are hearing of this term. Basically what it is that you have a primary partner. Of course, that's your married partner. We have monogamy. I have already stated that Hindu Marriage Act is there, so monogamy is the rule. But these days, apart from this primary relationship, side by side, you also go through secondary relationships. In the sense, you have your wife, everything is there, but you also want to have some other sexual partners. So, and these husband and wife, they know about each other. The wife can also have other sexual partners apart from the husband. The husband can also have other sexual partners apart from the wife. And they know this thing each other. It could be on account of, there could be, I'll say whether it's useful or it's not a useful. We do say in our everyday life that variety is the spice of life. So you might become bored with one spouse. So you want to explore, you want to have adventure in your life. So, and both these, the couple knows about it, that he has his secondary partners, and the other one also knows that she has her secondary partners. But it has its both pros and cons. It could be, one thing that is very important under it is that there should be trust. If trust is not there, people do feel that if you are having more sexual partners, you are more happy, your life, it doesn't become monotonous. And by monogamy, at one point of time, you become bored, you want to have adventure in your life. So these are the things that people do say. But it also has its negatives. If you have secondary partners and one main partner, the thing is that it is time consuming. You need to give time to those persons. It is expensive. You have to spend money on those people also. It could be your wife might become jealous at one point of time. So when you are possessive about something, and if you see that your partner is going somewhere else, although you had agreed to that particular thing, but at one point of time you even might feel jealous on that point. Then it could be that you are having so many sexual partners apart from your spouse. You might end up having a sexual disease. It could be HIV, it could be any sexually transmitted diseases. So it has its plus and negative point. But plus, you can say you become more communicative, you become more expressive, you meet a lot of people, a lot of networking is there. Then there is no boredom in your life. You have so many partners with you, and your main partner is also there, primary partner is there, and others are also there. So it has its plus and negatives. So this is what the open marriage concept is. It's not so much in India as yet, though people are doing it, but nothing is there on this open marriage as far as India is concerned. So these are the new concepts that are being coming into operation. I will bring this lecture 9 to an end here only. I'll put a halt here. And then we have talked about so many things today. I started with succession of a Hindu female. We talked about certain provisions. Then we talked about domestic violence. There are many provisions. It is totally a women comrade legislations. The rights of the men have been taken away. There are so many, if you see the provisions, it's totally one-sided. And men, they do not have any remedy, and that was the reason they had stated that on this particular date they will be observing Barsi, and they'll go to Jantar Mantar every year and will observe Barsi, because it is totally anti-men. It is not gender neutral, it is totally gender biased, where women have been, the act has taken away every right of men. He doesn't have any remedy in the court. On one complaint, he is behind the bars and he doesn't have any remedy. So these things should not be called for. We should have gender neutral laws so that both the parties are not able to take advantage. They are not able to take the benefit of any of the things that is being enacted in order to ameliorate your situation, in order to perk up your situation. So the gender neutral laws should be there. Then the last we discussed in today's lecture was on open marriage. It's a very, very new concept, not that yet in India. In India, we have a traditional and a gullible society, and we are not that much open to all these concepts. We have 1955 Act, Hindu Marriage Act, had brought into picture the monogamy and one man and one woman at one time. And although earlier to this 1955 Act, polygamy was there, but this act had specifically, because we do pay importance to marriage in our life. So marriage plays a very pivotal role in our life, and we do still consider it to be a sacrament, a thing which we usually worship, a thing that we usually respect. But this concept of open marriage is totally incongruous to the concept of marriage in our society. So here you have your partner, of course that monogamy thing is there, that is your primary relationship, but side by side you also have secondary relationships. It could be relationships in the form of emotions, it could be relationships in the form of sexual nature, it could be in the form, so when you have, apart from your spouse, you also have other partners in your life. That's a case of open marriage, and it is not that you are hiding from your spouse. Your spouse knows about it, both of them knows about it. It has its plus, it has its minus, though people do feel that they should have, nowadays youngsters are having this feeling that there should be an adventure in one's life, but if this adventure is at this cost, so they really need to think over it, they really need to ponder over it. So it has, I've already talked about its plus and minus signs, so that's a very new concept. Open marriages, and let's see what happens to it, because it's just a new concept. Plus and minus we have already discussed in this lecture. In my next lecture I would be taking some other issues, it might be emerging also. So I will put an end to this lecture today. That was my lecture 9, and thank you so much for patient hearing, thank you so much for being with me, and thank you so much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school and, or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.